501. The court, option A, can allow amendment of pleadings at any stage of the proceedings. Option B, a party can amend its pleadings at any stage. Option C, cannot allow amendment of pleadings. And option D, can allow amendment of written statement only. Here, correct answer is option A. The court can allow amendment of pleadings at any stage of the proceeding. Question number 502. Pleading can be amended under which of the provisions of the CPC? Here, correct answer is option D. Before either the trial court, first appellate court or second appellate court. Here, pleading can be amended. Question number 503. Order 6, Rule 17 of CPC. The amendment of pleading may be allowed. Option A, as may be necessary for determining the real controversy between the parties. Option B, as to introduce an entirely new and inconsistent case. Option C, as to take away a right of defendant which has accrued to him by lapse of time. And option D, as to withdraw the admission made. Here, correct answer is option A. Under Order 6, Rule 17 of CPC, the amendment of pleadings may be allowed as may be necessary for determining the real question of controversy between the parties. Question number 504. Under Order 6, Rule 17 of CPC, an application for amendment of pleadings can be allowed. Option A, before the commencement of trial. Option B, after the commencement of trial. Option C, either before or after the commencement of trial. And option D, none of the above. Here, correct answer is option C, either before or after the commencement of trial. Question number 505. Which of the following proposition is incorrect? Insofar as the power to permit amendment of pleadings under Order 6, Rule 17 of CPC is concerned. Option A, amendment of pleadings must be allowed at any stage of the proceedings before the trial has commenced. Option B, amendment which cause prejudice to the other side may not be allowed by the court. Option C, the basic or cardinal test for deciding whether an amendment should or should not be allowed is the real controversy test. Option D, the court is normally prescribed from deciding the correctness or falsity of the case in the amendment when deciding an application for the amendment. In question number 505, here it has been asked which of the following proposition is incorrect. Here option A is incorrect, that is amendment of pleadings must be allowed at any stage of the proceeding before the trial commenced. This is incorrect. Question number 506. For the purpose of amendment of pleadings under Order 6, Rule 17 CPC, the commencement of trial takes place when the issues are framed, when the affidavits and evidence are filed, when the affidavits and evidence are tendered by the witness, and option D, once cross-examination begins. Here, correct answer is option A, when the issues are framed. Question number 507. If the party who has obtained an order to amend the pleadings under CPC, if not amended after the expiration of how many days, shall not be permitted to amend the same without the leave of the court? Correct answer is option C, that is 14 days. Question number 508. Under Order 7 of CPC deals with, correct answer is option B, that is plaint. Order 7 of CPC deals with plaint. Question number 509. Order 7 Rule 1 of CPC is related to pleadings, written statement, particulars to be contained in plead, none of the above. Here, correct answer is option C. Order 7 Rule 1 of CPC is related to particulars to be contained in plaint. Question number 510. It is a statement of a claim of a document by the presentation of which the suit is instituted. It is called as, correct answer is option D, that is plaint. Question number 511. Where the subject matter of the suit is immovable property, the plaint shall contain option A, a description of the property sufficient to identify it. Option B, in case where the property can be identified by the boundaries or numbers in a record of settlement or survey, the plaint shall specify such boundaries or numbers. Option C, the detail of the owner of property in question has to be mentioned in the plaint. And option D, both A and B. In question number 511, correct answer is option D, that is both A and B. Option A, a description of the property sufficient to be identified. And option B, in case where the property can be identified by the boundaries or a number in a record of settlement or survey, the plaint shall specify such boundaries or numbers. Question number 512. Order 7 Rule 10 of CPC provide for, option A is the right answer, that is return of plaint. Order 7 Rule 10 of CPC provides return of plaint. Question number 513. A plaint is liable to be returned when, option A, a plaint is on an insufficiently stamped paper. Option B, plaint is not filed in duplicate. Option C, relief is undervalued in the plaint. And option D, plaint is filed in a court having no jurisdiction. Correct answer here is option D. A plaint is liable to be returned when plaint is filed having no jurisdiction. Question number 514. A court can return the plaint for presentation to the court in which the suit should have been instituted at the time of the institution of suit, before framing of issues, before the trial begins, at any stage of the suit. Here correct answer is option D, at any stage of the suit. Question number 515. A court can return the plaint when the court has got no territorial jurisdiction, no pecuniary jurisdiction, no subject matter jurisdiction, any of the above. Correct answer is option D. A court can return the plaint when the court has got any of the above. No territorial jurisdiction, no pecuniary jurisdiction, no subject matter jurisdiction. Question number 516. Under CPC, if the court finds at any stage that it has no pecuniary jurisdiction with respect to the subject matter of the suit, it will option A, dismiss the suit, option B, proceed with the suit, option C, amend the suit, and option D, return the suit. Correct answer here is option D, return the suit. Question number 517. In case the suit has been instituted in a court having no jurisdiction, territorial or pecuniary, the plaint is liable to be returned. Option A is the right answer. Question number 518. Order 7 Rule 10 to 10B provides for return of plaint, admission of plaint, rejection of plaint, documents relied on in plaint. Correct answer is option A. Order 7 Rule 10 to 10B provides for return of plaint. Question number 519. Procedure for return of plaint is provided in. Correct answer is Order 7 Rule 10 Clause 2. Return of plaint is provided in Order 7 Rule 10 Clause 2. Question number 520. Whether the appeal or revisional order can return the plaint under Order 7 Rule 10 of CPC after setting aside the decree. Correct answer here is option D, that is yes. Question number 521. On which of the following ground the court shall return a plaint? Option A, the plaint to be presented to the court in which the suit should have been instituted. Option B, the plaint does not disclose cause of action. Option C, the plaint is not found in duplicate. And option D, the suit appears from the statement in the plaint to be barred by law. Correct answer here is option A. On which of the following ground the court shall return the plaint? Court will return the plaint when the plaint is to be presented to the court in which the suit has to be instituted. Question number 522. In which order and rule of CPC the power of appellate court to transfer suit to the proper court has been given? Here correct answer is option C, that is Order 7 Rule 10B. Question number 523. A plaint can be rejected. Option C, under Order 7 Rule 11 of CPC. A plaint can be rejected under Order 7 Rule 11 of CPC. Question number 524. On which ground plaint can be rejected? Option A, where it does not disclose the cause of action. Option B, plaint is filed in such court which does not have the jurisdiction to try the suit. Here correct answer is option B only. On which ground plaint cannot be rejected? Option B, plaint is filed in such court which does not have jurisdiction to try suit. Whereas plaint can be rejected where it does not disclose the cause of action and where the suit appear is barred by law and where the plaint is not filed in duplicate. Here in this question it has been asked on which ground the plaint cannot be rejected. Plaint cannot be rejected when it is filed in such court which does not have jurisdiction to try the suit. Option B here is the right answer. Question number 525. Choose the true statement about propositions. Propositions are: every suit presupposes the existence of cause of action against the defendant. Second, if there is no cause of action, the plaint will have to be rejected. Third, failure in indicating the date of the accrued of causes of action is fatal to be filing the suit. Here correct answer is option D, that is all are correct. Once again I am repeating the propositions. First, every suit presupposes the existence of cause of action against the defendant. If there is no cause of action, the plaint will have to be rejected. Third, failure in indicating the date of accrued of causes of action is fatal to be filing of the suit. Question number 526. The court can reject the plaint under Order 7 Rule 11E of CPC if it is not filed in. Here correct answer is option B, that is duplicate. If it is not filed in duplicate. Question number 527. The plaint should be filed in duplicate. This rule was inserted by. Correct answer is option B, that is CPC Amendment Act 2002. Question number 528. Suit was filed on 2011-2012 and it has been specifically pleaded that cause of action arose on 6/10/2012. Defendant appeared and without filing written statement, he filed an application under Order 7 Rule 11 of CPC on the ground that suit is barred by limitation. State what is the correct legal proposition. Here options are: application under Order 7 Rule 11 CPC is not maintainable because written statement should be filed firstly. Second, Plaint shall be rejected because suit is barred by the law of limitation. Third, dismissal of application will be proper. Objection could not be decided without recording evidence of parties. And D, application should be allowed because plaints does not disclose the correct cause of action. Here in question number 528, correct answer is option C. Dismissal of application will be proper. Objection could not be decided without recording evidence of the parties. Question number 529. Mark the incorrect statement. Option A. The court must be competent to try the suit at the time of filing of the suit. Subsequent change in value does not affect the jurisdiction. B. If it is the plaintiff's valuation in the plaint that determines the jurisdiction of the court and not the amount on which ultimately the decree may be passed by the court. C. If the pecuniary jurisdiction of the court is rupees 10,000 and the plaintiff files a suit for accounts and finally the court finds on taking the amount that 15,000 are due, the court is not deprived of its jurisdiction to pass a decree for that amount. D. If the plaintiff undervalues or overvalues a claim for the purpose of choosing the forum, it is not the duty of the court to return it to be filed in the proper forum. Here in this question, it has been asked which question is incorrect. Option is incorrect. Option D here is the incorrect option. Now let us proceed to question number 530. Question number 530. Where the plaint is not filed in duplicate, the plaint may be returned by the court, rejected by the court, dismissed by the court, admitted by the court. Correct answer here is option B, that is rejected by the court. Question number 531. A defendant can pray to the court for rejection of a plaint if the stamp writing is not clear, if it is barred by another enactment of the parliament, if the plaint is made in foreign language, none of the above. Correct answer here is option B. A defendant can pray the court for rejection of a plaint if it is barred by another enactment of the parliament. Question number 532. A plaint shall be rejected if it does not disclose the cause of action, if it is filed in the wrong court, if proper parties are not added, none of the above. Correct answer here is option A. Plaint shall be rejected if it does not disclose the cause of action. Question number 533. Under which provision of CPC a plaint is rejected by the courts in the absence of cause of action? Correct answer here is option A, that is Order 7 Rule 11 Clause A. Question number 534. When a court can reject a plaint? Here options are where plaintiff fails to comply with Rule 9, option B where suit is barred by law, and option C where the plaint is not filed in duplicate, all of the above. Here all the options are correct, therefore option D will be the right answer. Question number 535. After rejection of a plaint, whether plaintiff can institute fresh suit on the same cause of action? Options are can institute another suit, option B cannot institute another suit, option C can institute with the permission of the High Court, and D none of the above. Here correct answer is option A, can institute another suit. Question number 536. On rejection of a plaint under provisions of Order 7 Rule 11 of CPC, presenting of a fresh plaint in respect of the same cause of action is option A, barred by the principles of res judicata, option B, on its own force does not preclude the plaintiff from presenting a fresh plaint, and option C, barred under Order 23, and option D none of the above. Here correct answer is option B, on its own force does not preclude the plaintiff from presenting a fresh plaint. Question number 537. Rejection of a plaint is challengeable under section 96 of CPC, not challengeable and only a fresh suit can be filed, challengeable under section 115 CPC, D challengeable under section 102 of CPC. Correct answer here is option A. Rejection of a plaint is challengeable under section 96 of CPC. Question number 538. A fresh suit on the same cause of action is not barred when rejected under Order 7 Rule 11 of CPC, dismissed under Order 9 Rule 2 of CPC, dismissed under Order 9 Rule 3 of CPC, and option D either A, B or C. Here correct answer is option D. A fresh suit on the same cause of action is not barred. Here correct answer is option D. Question number 539. On which of the following grounds a plaint will not be rejected? Option A, where the suit appears from the statement in the plaint to be barred by any law. Option B, where the relief claimed is undervalued and a plaintiff, on being required by the court to correct the valuation within a time fixed, fails to do so. And option C, where it does not disclose a cause of action. Option D, where it has not been presented by an advocate. Correct answer here is option D, where it has not been presented by an advocate. On this ground, the plaint will not be rejected. Question number 540. Which one of the following is a newly added ground for rejection of a plaint under Order 7 Rule 11 of CPC? Option A, non-disclosure of cause of action. Option B, undervaluation of the relief claimed. Option C, barred by any law. And option D, plaint not filed in duplicate. Here correct answer is option D, plaint not filed in duplicate is the correct answer. Question number 541. Order rejecting plaint under Order 7 Rule 11 of CPC is a decree, is an order, is a deemed decree, is an interim order. Correct answer here is a deemed decree. Order rejecting plaint under Order 7 Rule 11 of CPC is a deemed decree. Question number 542. Under Order 7 Rule 11 of CPC, the plaint shall not be rejected. Option A, where it discloses the cause of action. Option B, where the suit appears from the statement in the plaint to be barred by any law. And option C, where the plaintiff fails to comply with the provisions of Rule 9. And option D, where it is not filed in duplicate. Here correct answer is option A. Plaint will not be rejected where it discloses the cause of action. If the cause of action was not disclosed, then only the plaint will be rejected. So here option A will be the right answer. Question number 543. A filed a suit against 3 defendants. Defendant number 1 alleged that there was no cause of action against him under Order 7 Rule 11D of CPC. The plaint is to be option A, rejected in a whole, rejected in part if the cause of action is not joint and several. And option C, proceeded with against all defendants. Option D, none of these. Here correct answer is option C, proceeded with against all defendants. A filed a suit against 3 defendants. Defendant number 1 alleged that there was no cause of action against him under Order 7 Rule 11 Clause D of CPC. The plaint is to be proceeded with against all defendants. Question number 544. The document on which the plaintiff relies upon in support of his claim shall be filed by him in the court along with the plaint. Option A here is the right answer. Question number 545. Where a plaintiff sues upon a document in his power of possession, he must produce it or a copy thereof along with the plaint at the time of giving evidence, at the time of framing of issues, when ordered by the court. Here correct answer is option A, along with the plaint. Question number 546. The provisions relating to particulars of the written statement and counterclaim is in Order 8 of CPC, Order 9 of CPC, Order 10 of CPC, Order 11 of CPC. Here correct answer is option A, that is Order 8. The provision relating to particulars of the written statement and counterclaim is in Order 8 of CPC. Question number 547. The meaning of written statement is suit of plaintiff, suit of defendant, answer by defendant of the plaintiff's suit. Here option C is the right answer. The meaning of written statement is answer by defendant of plaintiff's suit. Question number 548. Time limit for filing written statement is 30 days, which may be extended up to 90 days, shall be counted from date of filing of the suit, date of first hearing fixed by the court, date of service of summons on the defendant, none of the above. Here correct answer is option C, that is date of service of summons on the defendant. Question number 549. The period of limitation within which defendant shall submit his written statement is ordinarily within. Correct answer here is option C, 30 days from the service of summons or 90 days if allowed by the court. 30 days from the service of summons and 90 days if allowed by the court. Question number 550. A defendant should present written statement of his defense within 30 days from the service of summons to him. The said period can be extended up to, it can extend it up to maximum 90 days. Here option C is the right answer.